We are self-help services at the Orange County Superior Court. Thank you for signing up for our divorce, legal separation, and nullity online workshop. We hope that this video will help you successfully participate in the upcoming workshop. We will go over some basic terms that will help you complete the workshop packet that you received with the link to this video. You can pause, rewind, and watch this video at your own pace as you work on your packet. Keep in mind that you will have to make choices about your situation as you complete the workshop packet and throughout your family law case. Self-help services can explain the rules and procedures in your case, but we cannot make any decisions for you. You are here today because you want to learn more about how to end a marriage or domestic partnership. Let's start by learning the difference between a divorce, legal separation, and nullity in case it applies to your situation. Divorce. A divorce ends your marriage or domestic partnership. A divorce is also called a dissolution of marriage or dissolution of domestic partnership. After you get divorced, you will be single and certain responsibilities to and from your spouse will end. Once your divorce is final, you can also get married again or enter into another domestic partnership. If you are married and want to get a divorce in Orange County, you must meet California's residency requirements. This means that either you or your spouse must have lived in California for the last 6 months and Orange County for the last 3 months. If you do not meet these requirements, you cannot file for divorce in Orange County at this time. If you do not want to wait to file your case, you can first file for legal separation. Once enough time has passed that you meet the requirement, you can file what's called an amended petition and ask the court to change the legal separation into a divorce case. Legal separation. A legal separation does not end your marriage or domestic partnership. You cannot marry or enter into a domestic partnership with someone else even after you are legally separated. However, like a divorce, when you get a legal separation, you can ask the court to make orders about custody and visitation, child support, spousal support, and dividing property from the marriage. Sometimes couples decide to file for legal separation instead of divorce for personal, religious, or financial reasons. There are no residency requirements to file for legal separation. Nullity. A nullity of marriage or domestic partnership, or annulment, does not end a marriage or domestic partnership. Instead, it is a way to say that your marriage or domestic partnership is not legally valid. To get a nullity, you have to prove in court that your marriage or partnership is not legal for a specific reason provided under the law. Despite what you might have seen in movies or on TV, nullities are very rare, and getting a nullity does not depend on how long you have been married, even if it was only a very short time. If you want to file for a nullity, we strongly recommend that you first get legal advice from an attorney or conduct your own legal research. Date of separation. To start your case, you will need to know your date of marriage or registration of your domestic partnership. You will also need your date of separation. If you do not know your date of marriage or registration of domestic partnership, check your certificate of marriage or registered domestic partnership. The date of separation is something you will need to determine yourself. The date is important because it can affect how property gets divided and spousal support, for example. The date of separation is the exact date when there was a complete and final break in your relationship. That means you or your spouse told the other person that they wanted to end the relationship and acted in a way that shows they wanted to end it. For some people, the date of separation is the day they moved out. For others, it's the day they agreed that their marriage was over and they made plans to separate. Although the act of moving out and living separately may be the easiest way to determine the date of separation, a couple can be separated even if they still live together. Property. Your court case will also address your assets and debts. Assets include anything of value that can be bought or sold, like a house, cars, furniture, or clothing. Assets also include anything that has value, such as bank accounts and cash, security deposits on apartments, pension plans, 401k plans, stocks, life insurance that has cash value, or a business. Examples of debts include a home mortgage, credit card balances, other loans. Even if you do not want to deal with these issues, or even if you divided your property informally when you separated, California law requires you to list in your court forms any assets and debts that belong to you, your spouse, or the two of you together. To complete your paperwork properly, you will need to understand the difference between community and separate property. Community property is generally everything you bought or got after your date of marriage and before your date of separation, including debt. Community property also includes all the earnings that either spouse or partner, or both of you together, earned during the marriage or partnership, and everything you bought with those earnings. You can usually tell if something is considered community property by looking at where the money used to buy something came from. For example, if you used money that one of you earned during your marriage to buy a car, it is considered community property. It does not matter whose name is on the car title or who actually uses or physically has the car. Community property, both assets and debts, is generally divided equally between parties. Separate property in California generally means anything that you or your spouse owned, earned, or owed before your date of marriage or after your date of separation. Also, gifts and inheritances that either of you received at any time, even during the marriage, are separate property. Generally, student loans taken out during marriage for one party will also be considered separate property. If you have separate property, it generally belongs only to you. Commingled property. Sometimes, property is part separate property and part community property that have been mixed together through something called commingling. For example, if you have a savings account that you had before your marriage, that account would be considered a separate property asset. But if you deposited your paychecks or other earnings during marriage into that account, those funds would be considered community property. In this example, you would need to list the bank account as both community and separate property in your workshop packet. Later in your case, you will need to figure out how to properly divide up the funds in the account. Children. If you have children with your spouse or domestic partner, and those children are under the age of 18, you will need to make certain decisions on who will care for your children, where they will live, and when they will see each parent. Child custody has to do with the rights and responsibilities of parents on taking care of their children. Sometimes, parents can agree to a plan. Other times, they cannot agree, and the court will decide the plan based on the best interest of the children. Until you have a court order, both parents have the same rights and can make decisions about their children. There are two types of custody that will come up in your case, and you will need to make your choices for each type. Legal custody is about the right to make important decisions for your child regarding their health, education, and well-being. For example, a parent with legal custody will decide where a child goes to school, what doctor or dentist they see, and the religion in which they will be brought up. Sole legal custody means that one parent gets to make major decisions on these issues, and if there is a disagreement between the parents, the parent with sole legal custody has the final say. Joint legal custody means that the parents make these big decisions together and share these responsibilities. Physical custody refers to who your child lives with most of the time. Sole or primary physical custody means that the child lives with one parent most of the time. Joint physical custody means that the child spends a similar amount of time with each parent. Visitation or parenting time is the plan for how parents will share time with their child. A parent who does not have physical custody will usually have visitation rights. The visitation plan will depend on your family's situation and the best interests of your child. Most of the time, it is helpful for parents and the child to have a set schedule with the dates and times that the child will be with each parent. There are other types of parenting time arrangements, such as reasonable and supervised visitation, depending on your family's situation. Child support. As a basic rule, both parents must financially support their children. Child support is the amount of money that the court orders a parent or both parents to pay every month to help pay for the child's living expenses. Usually, child support is paid to the parent primarily caring for the child, but there are exceptions. The court will usually order support based on a set formula, also referred to as a guideline amount. The guideline calculation will look at how much each parent makes, how they file taxes, how much time they spend with the children, and other factors. You do not have to complete any questions regarding child support in your workshop packet. Spousal or partner support. When a couple legally separates or divorces, the court may order one spouse or domestic partner to pay the other a certain amount of support money each month. This payment is called spousal support for married couples and partner support in domestic partnerships. It is sometimes also called alimony. Spousal or partner support will depend on the specifics of your case. As you finalize your case, you could decide to 1. Request spousal or partner support, 2. To reserve on support, meaning you don't want the court to decide now, but could request it in the future, or 3. End the ability of the court to award spousal or partner support forever. Many marriages or domestic partnerships end without either spouse paying this type of support. But in some cases where the marriage was long, spousal or partner support can last for many years. If you do not agree on support, the judge is required to look at certain factors required by the law to decide the length and amount of support. We hope that you found the information in this video helpful. Please make sure to complete the workshop packet and submit it to our team. If you get stuck while working on the packet, please contact Self-Help Services at least 2 days before the workshop date so you don't lose your spot. Thank you.